This is a passage from the paper on the common law of defamation. And this is a passage reads. Malaysia and Hong Kong courts have applied the Reynolds privilege. In contrast, the Singapore Court of Appeal in the Fear case, Far Eastern Economic Review, has decided for the present at least not to adopt the Reynolds privilege for matters of public interest. As a result of the Court of Appeal's decision to maintain the status quo on the defense of qualified privilege, the Singapore position has effectively diverged from England and several other parts of the Commonwealth. Well, I think the passage is not quite accurate. The Court of Appeal held that the Reynolds privilege did not apply under the common law of Singapore to a foreign defendant, as non-citizens do not enjoy constitutionally protected speech. The court held that the Reynolds privilege was based on the English courts elevating the common law right of free speech to a right of a higher legal order as a consequence of the United Kingdom being bound by the European Convention for the Protection of Human Rights and Fundamental Freedoms and the enactment of the Human Rights Act 1998. In contrast, although freedom of speech in Singapore is also a higher legal order right, because it is a constitutional right under Article 14, that article does not apply to non-citizens or corporations owned by them. Hence, to allow the defendant to rely on the Reynolds privilege would be to accord the constitutional right of free speech to a non-citizen by the back door. That was the essence of the court's decision. But the Court of Appeal in that judgment also suggested that if the Reynolds privilege is not accepted as a defense of liability, it can still be considered as a mitigation factor in damages. Now, I would have thought that any academic commentator would seize on that suggestion and make a meal of it. Final example is from the paper on directors' duties and minority oppression. In the last 5 years, the Court of Appeal gave a series of decisions on disputes of that nature. However, in a number of cases, the Court was not so much concerned with the law, since the broad principles are settled, but with how to provide practical solutions to the parties, so that each would go away getting what each wanted. In other words, the Court had attempted to be solution-oriented rather than doctrine-oriented. So in the case of Sim Yong Kim, the Court of Appeal went out of its way to set down in considerable detail conditions and directions to ensure that the parties obtained a fair resolution of the dispute, with the possibility of an amicable settlement being left open. Similarly, the court order in another case, Chow Kok Chun, was conditional so as to leave the door open to an amicable settlement of the disputes. Now, in its latest decision on company law, the Court of Appeal in the OCBC and the TT International Limited case not only ordered a revote on the scheme of arrangement to address the grievances of the creditors that it lacked transparency, it also imposed conditions for sanctioning the scheme after the second vote to allow itself a continuing supervisory role in implementing the scheme. In other words, the court interpreted Section 2010(4) of the Companies Act broadly to enable it to allow the company to be recognized in a manner almost resembling a Chapter 11 reorganization. So I think I've said more than enough to encourage the participants today to engage the speakers on their views so that there can be a lively discussion following their presentations. Well, many of you may look back in wonder or distress at what the courts have done to the law in the past 5 years, but more importantly, a conference of this nature can be a wake-up call to the judges to do better than what they have done in the past. So let me conclude by thanking the organizing committee and the staff of the Singapore Academy of Law who have worked so hard to organize this conference, and also the speakers and participants for making this conference possible. So I now have great pleasure in declaring open the 4th Singapore Academy of Law Conference. Thank you very much.